Namaste, I hope that you're doing well. Let us cover out the demonetization judgment. So this is most likely going to be popping up in CLAT 2024. However, if it does not, it will forever now pop up because this is one of the landmark judgments of the Supreme Court. We will now extract MCQs out of it, just like we always do. I will attach the PDF with the lecture. In this, instead of taking screenshots from the judgment, I have extracted out text. Let us see how it goes. Otherwise, we'll revert to our previous approach of extracting screenshots from the judgment. So it was a 5-judge bench. That is the first MCQ. How many judges were there? It's 5-judge bench. Who dissented? The first, to be the first CJI, or rather the first ever female CJI who is going to be in the future, will be BV Nagarathna. So she dissented in this judgment. Now this is absolutely crucial. In the Sabrimala judgment, we had Justice Indu Malhotra who dissented, and in the Adhar judgment, that is K. Puttaswamy, Justice Chandrachud dissented, and in this BV Nagarathna dissented. Alright, so this is extremely crucial. So they upheld demonetization, which was done in 2016 by 4:1. The one dissent was by BV Nagarathna. Alright, so the main act, that was the main statute that is involved, is RBI Act 1934. I'll just change the color of the pen to make life easier for us. Now it is good. Okay. Now, so when was Notebandi done? The demonetization exercise, the date on the 8th of November 2016, and the 500 rupees and 1000 rupees notes were, well, banned. This ceased to be legal tender. And under which section was this done? So of course a notification had been issued, and then an ordinance came in, then it was turned into an act, right? All of those are relevant MCQs. So section 26 subsection 2 specifically, all right, I'll use this color and I'll change this one as well so that black or purple वगैरह अलग दिखाई दे. All right, so gives the union the power to declare that specific currency notes are no longer legal. All right, so this becomes extremely important. Mark it in your notes. Of course this PDF is going to be there, but I need you to make bullet points. अगर आप PDF पे, like let us say that you're working on an iPad, or if you're working on a on any electronic device only and you're not taking printouts of this, you just highlight this. All right, and this judgment was delivered on the 2nd of January 2023. The judgment date is also sometimes asked in CLAT PG. Okay. Now, CLAT PG is very fond of asking you who all were on the bench. So, Abdul Nazir, B.R. Gawai, A.S. Bopanna, V. Ramasubramaniam, and B.V. Nagarathna. Justice Chandrachud was not there on the bench of this judgment. Which of the following was not there on the bench? All right, and the case law name is Vivek Narayan Sharma versus Union of India. All right, case name of course becomes important. SBN, दो जो abbreviations उन्होंने बहुत बारी पूछी हैं in the judgment, or they've referred to it as SBN, stands for specific banknotes, and KYC is know your customer. Both of these MCQs are very important. Now it says on the 30th of December 2016, the specified banknote cession of liabilities ordinance, referred to as the 2016 ordinance, was promulgated by the Honorable President of India. Subsequently, the Parliament enacted the Specified Banknotes Liabilities Act 2017, Cession of Liabilities Act, which received the assent of then Honorable President. So these are the main statutes which eventually ended the validity of the older currency notes, the 500 and 1000 wale notes. So therefore these become important, especially the act is of significant importance because ordinance ka naam वगैरह सब same ही रहता. Now let us see. It says section 3 of the 2017 act provides on and from the date appointed notwithstanding contained in any other, the SBNs which had ceased to be legal tender in view of the impugned notification of the Government of India shall cease to be liabilities of the RBI under section 34 of the RBI Act. So this section becomes important, under which, so you need not enter into deep waters in the RBI Act and hunt for MCQs. These are the sections that they're referring to. Therefore, these are the very MCQs that are going to be asked, right? So section 34 important ho gaya. And then yeah, आपका section 3 in the 2017 वाली act, कौन सी act? वो जो SBN वाली जो act है, ये specified banknotes, इसके अंदर का section 3 becomes important. Section 34 of the RBI Act becomes really important. All right. Okay. Now, basically, there were two prior demonetizations also that were done. There was one was done in 1946. The other was done in 1978. Both of these years are very, very important. So this is the third time demonetization has happened in the country. The earlier two become important, that is 1946 and 1978. Then the judgment often refers to the four-prong test as set out in the judgment of this court in the case of Modern Dental College and Research Center and others versus the state of MP. Now this test is extremely crucial. They are going to, if this judgment pops up, of course, in the question paper, they are going to ask you four-prong test किस judgment के अंदर declare हुआ था. So Modern Dental College याद करने का तरीका चार दांत थे. This is just a joke, but याद करने का तरीका. Okay. Now they refer to Section 8 of the RBI Act in comparison to Central Board and Term of Office of Directors. The Central Board shall consist of the following directors, namely a governor and not more than 4 deputy governors. So there is a Central Board within the RBI which consists of a governor and not more than 4 deputy governors. Slightly low probability, however, we will still mark it in our notes. Okay. Now it goes, they refer to a theory known as, or rather a principle of interpretation of statutes, that is purposive interpretation. Alright, most likely is going to pop up if they ask this judgment. So it says legislation has a name, it seeks to obviate some mischief, to supply an inadequacy, to effect a change of policy, to formulate a plan of the government. That aim, that policy is not drawn like nitrogen out of the air. It is evidenced in the language of the statute as read in the light of other external manifestations of purpose. Something like doctrine of pith and substance, that they want to interpret it in such a way that is in alignment with what the legislature intended, and that intention is visible in the language of the statute as it is read well in context of everything else. So that is purposive interpretation. Whatever the purpose the legislature wanted to achieve, the court has to interpret a statute according to purposive interpretation. Now, of course, this is just one principle of the interpretation of statutes. Okay. Now, it says, it is thus clear that it is a central principle that the modern approach of interpretation is a pragmatic one and not pedantic, an interpretation which advances the purpose of the act and which ensures the smooth and harmonious working must be chosen, and the other which leads to absurdity. अच्छा ये जो numbers जो दे रखे हैं, when I was copying from the judgment, तो ये citation वगैरह copy हो रखी है. I didn't edit it out, so just ignore these numbers. Absurdity or confusion or friction or contradiction and conflict between its various provisions. So they can give you this quotation. An interpretation which advances the purpose of the act and which ensures a smooth and harmonious working is known as purposive interpretation. याद रखिएगा, ठीक है जी? Okay. Then it says, then it refers to one case law, Tata Cellular versus Union of India, in which scope of judicial review was enunciated. Of course, judicial review has been enunciated in various other judgments. However, in this judgment, they are saying that we enunciated in Tata Cellular. तो टाटा सेलुलर कहीं अगर एग्जाम में दिख जाए और जुडिशियल रिव्यू कहीं कनेक्टेड हो, you know that they are connected now. All right. So the law with regards to scope of judicial review has very well been crystallized in Tata Cellular. In the said case, it has been held by this court that the duty of the court is to confine itself to the question of legality. Its concern should be whether a decision-making authority exceeded its powers, committed an error of law, committed a breach of the rules of natural justice, reached a decision which no reasonable tribunal would have reached, or abused its powers. So that is pretty much, so this is, they're telling you the contours of judicial review, the limitations of judicial review, which the court must stick itself or should be there within the boundaries. All right. The court held that it is not for the court to determine whether a particular policy or particular decision taken in the fulfillment of that policy is fair. As long as the body has the power to enact or rather work on a policy via some actions, it can only, the court can only, when going into judicial review, check whether the authority, well, did it breach the rules of natural justice? Did it exceed its power? Did it commit an error of law? Did it reach a decision which no reasonable tribunal would have reached, or would have reached? Only that. Except for that, the court cannot really dictate any policy decisions, even though in the past they have done so. However, we will not get into those political debates. Now, the four-prong test of proportionality, that is Modern Dental College and Research Center, this becomes extremely important, right? Four-pronged test of proportionality most likely is showing up in your exams. So in this case, we need not enter as to what was happening is, but a brief mudda balance between. So they were debating 19(1)(g) and the reasonable restrictions under the appropriate 19 clause 6 जो 19(1)(g) के साथ connect होता है, where part 3 fundamental rights, right? Thus, while examining as to now, so they were considering a balance between 19(1)(g) and reasonable restrictions. Between 19(1)(g) is to practice any profession, and 19(6) says, well, the government can in part or completely exclude citizens from, well, practicing their profession and technical and professional qualifications. Remember, if you don't, pause the Bare Act, revise 19(1)(g) and revise what is there in 19 clause 6, because that is also related to the doctrine of eclipse as enunciated in Bhikaji Narayan Dakras versus the state of MP. Okay. Now it says, thus, while examining as to whether the, अब ये कोई इस पे कोई रट्टा मत मार लेना घर पे बैठ के, thus while examining as to, नहीं, just basic core और जो मैं बोल रहा हूँ, the MCQs that they can ask from this. The imbued provisions of the statute and rules amount to reasonable restrictions and are brought out in the interest of the general public. The exercise that is required to be undertaken is the balancing of fundamental right to carry on occupation on the one hand and restrictions imposed on the other hand. This what is known as the doctrine of proportionality. All right, so this is that कि reasonable restrictions जो लगाई हैं आपने उस fundamental right के ऊपर, they should be in proportion. मतलब ज्यादा ही बिल्कुल ही खत्म कर दोगे तो फंडामेंटल राइट टेक्निकली स्पीकिंग हैवंट यू टेकन इट आउट ओनली, हैवंट यू एक्सपायर्ड द फंडामेंटल राइट. इफ द रीजनेबल रिस्ट्रिक्शंस आर नॉट इन प्रोपोर्शन, तो रीजनेबल रिस्ट्रिक्शंस वगैरह कैसे लगाएं या उसको टेस्ट कैसा किया जाए वेदर दिस इज एक्चुअली रीजनेबल इन नेचर और नॉट, बाय द फोर प्रॉन्ग टेस्ट ऑफ प्रोपोर्शनैलिटी. ऑलराइट, सो दैट इज द कोर क्रक्स. ठीक है जी, आगे चलते हैं. देन हमें ये याद रखना है कि चार हैं क्या, फोर प्रॉन्ग तो हमने कर दिया, बट चार है क्या. इट इज डेजिग्नेटेड फॉर अ प्रॉपर पर्पस. पहला, the measures undertaken to effectuate such a limitation, that is mostly reasonable restrictions, are rationally connected to the fulfillment of that purpose. So why are they referring to four pronged test of proportionality in Notebandi, that whether this was the entire, the entire country came to a standstill, whether this was really proportional to what they intended out to achieve. It is designated for a proper purpose, and whether that limitation is rationally connected to the fulfillment of that purpose. And then it says the measures undertaken are necessary in that there are no alternative measures that may similarly achieve the same purpose. So purposive interpretation, and again and again and again, purpose and proportion जो आप करना चाहते थे. If यहाँ पे जो तीसरा point है कि was there any alternate way in which that you could have done it, and if that would have been a better way. Alright, so they are testing whether, मतलब नोटबंदी, of course they upheld it, so they agreed, but एक बीवी नागरत्ना जी ने dissent कर दिया था. There needs to be a proper relation, that is proportionality stricto sensu or balancing. So ये अगर legal term पूछ ली तो कृपया करके mark out कर दीजिएगा, between the importance of achieving the proper purpose and the social importance of preventing the limitation on the constitutional right. So these four were given by Aharon Barak, that was the former Chief Justice of the Supreme Court of Israel. This is extremely important. Four-pronged test of proportionality was given by Aharon Barak, the CJI. या Aharon Barak का नाम भी लिख देंगे और CJI of Supreme Court of Israel. और अगले साल अगर ये पूछ लिया तो फिर दुनिया सारे के सारे बाकी दूसरी कंट्रीज के फॉर्मर CJI के नाम ना रट रही हो. नहीं रटने हैं भैया, ये this is a specific question from this judgment. Okay. Then it says dissent. Now जो dissent से जो MCQ, dissent was of course given by BV Nagarathna. So one of our main reasons was the central government may also initiate and carry out demonetization even in the absence of recommendation of central board of the bank. So she said that central board of the bank, as in via her dissent, this तो मैंने एक quotation निकाल ली है कि central board ने तो recommendation दी नहीं, so this was primarily done by the government. However, this must have been carried out only by acting a plenary legislation or a law in this regard, and not through issuance of notification under subsection 2 of the section 26 of the act as the provision. So the government, she says, अगर सेंट्रल बोर्ड ने, पहली बात तो सेंट्रल बोर्ड को रिकमेंडेशन देनी चाहिए थी, अगर उन्होंने नहीं दी है तो Government should have enacted an act instead of just issuing a minor C notification under subsection 2 of section 26 of the RBI Act 1934 and then just going as per their whim and fancy. They didn't follow the proper provision is basically her core argument. Alright. Now it says section 26A of the RBI Act. Now this is extremely important. Most likely they are going to be asking this section. Certain bank notes cease to be legal tender, notwithstanding anything in section 26. No bank note of the demonetization value of 500 rupees, 1000 rupees or 10,000 rupees issued before the 13th day of January 1946. ये डेट इंपॉर्टेंट है क्योंकि उस टाइम पे जब 1946 में डिमोनेटाइजेशन हुई थी तो 13th day of January 1946 से सब कुछ invalid हो गया था. So this is given in section 26A of the RBI Act. Alright. Then first demonetization was carried out on the 12th of January 1946. This date becomes really important. Just mark it out in your notes. To bring to realization the first demonetization the country witnessed. Give me 1 second. Yeah, this was on the previous page. Yeah. An ordinance was promulgated by the government on 12th January 1946. Okay. Second demonetization, as usual, our board keeps acting up. The second demonetization was carried out in the year 1978. याद रखिएगा. In pursuance of the recommendation of the Vanchu Committee, extremely important. इसको भी याद रखना. Appointed by the central government to recall the and well basically Vanchu Committee याद रखनी है. 1978 याद रखना है. 12 January 1946 याद रखना है. This is the third time demonetization was done in 2016. 8th of November 2016. Vivek Narayan Sharma dissented by Vivek Narayan 4:1 की judgment. The main judgment was authored by Justice Gawai. Justice D.Y. Chandrachud was not there. Justice Indru Malhotra dissented in the Sabrimala judgment. Alright. Quick fire, rapid fire. ठीक है जी. Okay. Internet Mobile Association of India versus RBI. This case law has been referred to, not exactly a very important case law for our purposes. However, wherein in one of us he says, while dealing with the regulation of cryptocurrency and virtual currency, highlighted the importance of the RBI. However, ये जो मुझे जो केस जो लग रहा है, जो अगर ये पूछेंगे कि क्रिप्टो करेंसी रेगुलेशन के ऊपर क्या केस था, इंटरनेट एंड मोबाइल एसोसिएशन ऑफ इंडिया वर्सेस आरबीआई, तो ये याद रखना है. एंड देन she referred to R.C. Cooper, that is Rustam Kawasji Cooper versus Union of India, also popularly known as the bank nationalization case. Alright, those are pretty much all the MCQs that I could find after scanning through the 382 page judgment. I think those were 60 main थी and then 100 page का dissent था. This is all that I think is the most important. Of course, with this lecture, the PDF is attached to save you time from making notes. जो मैंने highlight करा, you can either highlight it in the PDF or you can highlight it in your own notes. Now I see you in further lectures. I believe 1-2 lectures for the 2023 वाला काम हमने 1-2 और judgment करनी है, and that should be the most important one क्योंकि हम लोग काफ़ी सारा काम अब कर चुके हैं, and the ancillary subjects के lectures you guys must have already watched by now. If of course you are watching this in successive batches, then well, this gyan doesn't really apply to you क्योंकि pre-recorded है, तो of course I won't be editing it out later. Alright, now I see you in further lectures. Take